Welcome once again to Lehto's Law. Here's Steve Lehto.
A whole lot of people sent me this story because it comes from a press release issued by the Institute for Justice, our friends over there. And right at the end of the year, last year, on December 30th, the day before the end, they got word that the Ninth Circuit Court of Appeals had just ruled in their favor on a major case. So they sent out the note that they secured a resounding victory for property rights that could light the way for other IJ cases in the new year and beyond. The Ninth Circuit overturned a federal district court decision which had dismissed their class action challenging Humboldt County, California's unconstitutional code enforcement program. So at the lower court, they lost. The Institute for Justice lost. The judge goes, nope, dismissing your entire complaint. They take that to the Ninth Circuit Court of Appeals, who says, no. You guys can proceed. They spun it around and sent it back down. So the ruling affirms that government bodies cannot impose unconstitutionally excessive fines based on flimsy evidence and then delay hearings indefinitely. So you get a notice and it says, hey, we're going to fine you for something you're doing. And the fine, by the way, is cumulative and adds up every day. So every day you do what we think is wrong, you're going to owe us a ton of money. And you go, I want to appeal that. I want to actually have a hearing on that. I'm entitled to a hearing, right? They say, sure, you're entitled to a hearing. We'll set that up a few months down the road. While every single day, a fine is piling up on top of you. And so they actually have an incentive to not give you a swift hearing. So the opinion holds also that people can bring excessive fines challenges even if their fines haven't been paid yet, which sets an important precedent that will help many people who would otherwise have no access to justice. So here's what was happening. The governmental entity, the city, township, county, whatever it is, issues a fine and says, you are in violation every single day. This fine is going to be tacked on until you stop doing what we think is wrong. And you say, well, I want a hearing. They say, well, we'll get you one when we get you one. You say, that's not fair. So you file a lawsuit and they challenge it and say, hey, they haven't paid the fine yet. Therefore, they haven't been injured yet. So they have no proper standing to bring this action. And the Ninth Circuit has said, no, it's not their payment of the fine. The threat of a fine is enough if it's a real threat. So the lawsuit centered on Humboldt County's aggressive and unconstitutional code enforcement practices. Following the legalization of marijuana in California, the county created a system where property owners could face hundreds of thousands of dollars in penalties for alleged violations supposedly linked to the cultivation of the weed. Even when no cultivation had occurred, some fines were based on years-old satellite images with no on-the-ground investigation following up on it. Other fines were imposed because previous owners had grown there, even though the current owners were not involved in any way. So they go and they check their satellite imagery, and they go, hey, look what's happening on this piece of property. And of course, the satellite imagery might not have been shot today, and it turns out it wasn't. So one example is a client of the Institute for Justice who faced an incredible $104,000 in fines per day on land that she'd bought for $60,000. And it turns out that the previous owner had been shut down by the government, but had left behind the hoop houses under which you would grow plants. The county later reevaluated her fines, but still insists that she owes $7.4 million. Yeah, we've lowered it. It's only $7.4 million now. Well, 7.47, but that's okay. Making matters worse, owners had to wait years for hearings while fines continued to accrue, some to hundreds of thousands of dollars, often forcing settlements under duress. Now, you might say, but Steve, if they're really backed up, it might take them a few years to get you a hearing. Oh, you know that in some states, they started cracking down on drunk driving years ago. And they noticed that some drunk drivers liked having their hearings pushed way back. And some friendly prosecutors or friendly judges might say, oh, you know something, Bob? You've been in here before. I'll tell you what, as a favor to you, we'll push the hearing next year. They wrote right into the statute. It says, here's what happens when you drink and drive. And oh, by the way, you must have a hearing by this date. And it's usually a number of days. Okay? And they do that because they don't want people pushing hearings back to play with the system, to game the system. And so if they wanted to, they could hold these hearings sooner. Of course they could. But, it's better to have them rack up $104,000 a day in fines and drag it out from the perspective of the municipality. The Ninth Circuit not only revived the case, but embraced the legal theories, sending a strong signal to the lower courts. And this is important because it's a precedent and will substantially advance IJ's broader initiative to combat excessive fines and fees levied under the guise of zoning or property code enforcement. And by the way, you have to understand something. The Institute for Justice is not saying that the city, municipality, township, county, whatever it might be, they're not saying they don't have the right to do this in terms of enforce code. They're saying, fine, enforce it, but do it fairly. So if there's a fine, it can't be excessive. And if the person wants to fight the fine, they should get a hearing, a prompt hearing. And keep in mind that the Constitution does talk about how delays that hurt you are bad and that things should be done promptly, hence a speedy trial. But I suspect that speedy trials are more likely invoked in criminal cases where your freedom is at stake. And they'd make the argument and say, well, yeah, but your freedom's not at stake here. We're just going to fine the heck out of you. Well, it turns out that they got to do what they can to get you a timely hearing. So that's a big one as well. So Scott Bullock, who's the president and chief counsel at the Institute for Justice, I've met him, he's a nice guy. He says, thank you for standing with the IJ. We look forward to building on this momentum in 2025 in California and elsewhere as we continue to defend the rights of everyday Americans. So as I always say when I talk about the Institute for Justice, I'll put a link to their website in the description below the video. And you don't have to donate, but I would suggest you visit the site and just take a look at what they do and just follow them. Bookmark the page, sign up for their email. You'll get this type of stuff from them as well. And you'll get these updates and highlights. And the funny thing is that if you don't read the news and you don't watch videos like mine and you don't, follow this stuff, you might not know this stuff is happening. And I remember the first few videos I did about civil asset forfeiture. I got people responding in disbelief, saying, this really happens today? This can't happen very often. And as we've shined a brighter light on it, me and other people, but also the Institute for Justice, people like John Oliver, people are like, oh my gosh, it is more widespread than you'd think. And it's shocking, but until it happens to you, you might not think about it all that much. But you should be aware of stuff that's happening like this, because someday this could affect you. Now, this right here is specifically speaking to California, but I suspect it happens elsewhere. And I've heard of cases about overzealous code enforcement. And in fact, I talked about the case here in Michigan, where code enforcement people were flying drones over people's yards, despite the fact there were privacy fences around their yards. And the drones would be launched from quite a ways away to get over and view the yard. And then they would issue a fine and go, your yard's an eyesore. And who exactly is it offending now? People who fly drones over my property? Who else? And they took that one to the Michigan Supreme Court. The Michigan Supreme Court actually shot that one down. Excuse the weak pun, because they said, well, there's this right against unlawful searches and seizures, but a code enforcement action is not criminal in nature. But then again, I've never claimed that the Michigan Supreme Court was all that bright. I challenge you to find a video of mine where I have said the Michigan Supreme Court is a group of intelligent individuals. I've never said that. So getting back to this case, this is a huge win, and it came on New Year's Eve, as they say, end of last year. And I looked at the filing dates or the argument date, actually, when they argued the case. And they argued this months and months and months ago, but that's how courts work. You file the briefs, they call you in for argument, they say, thank you, we'll make a ruling, you leave, and then several months later, you get the news. And so it's good news here from the Institute for Justice, who just won a case in the Ninth Circuit, striking down excessive fees and fines and lengthy times before hearings on zoning issues arising in Humboldt County, California. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Recently, I ate at a real nice family restaurant. Every table had an argument going.